Good morning. Welcome to another exciting edition of Business Law. We're in what the heck week are we in? Just checking that out. It's starting with the 19th. There we go, week number 9. So when we finish this week, we will be 60% done with class. So that's fairly amazing. Let's take a look first at the discussions. Now, some of the comments made this past week were good. Again, my main comment is, not a lot of posts. Okay, kind of reminds you, my rubric that I use, is one post of reasonable quality is considered a 7, right? A C minus. And so keep that in mind as you're going ahead. So we had 8 posts. I know there's 4 or 5 in a group. So assuming everybody posted once, there was a couple maybe that posted twice. There might have been some outsiders that posted to this one as well. So keep that in mind, I guess, when you're kind of looking at the grades. But I'm sorry, I got a little humor in that one when we took a look at that. Oops, I clicked on the wrong thing. Didn't really want to click on the article. I was gonna take a look at some of the comments, and some of you brought up some fair things, about is this an ADA thing? Is it does the business need to make a reasonable accommodation, and what would that reasonable accommodation be? And it has to be an accommodation that doesn't create an undue hardship for the business, right? I don't know if they have a job where he can work, out of the way, maybe in his own office with good ventilation or something. I don't know, and the article unfortunately wasn't enough, probably to tell us that. Somebody mentioned that he should be granted time off while he's recovering and whatnot. That's true. The Family Medical Leave Act allows us a certain amount of time off, but you have to keep in mind it's up to 12 weeks, and it's also unpaid. And so it may not apply in this case. The fellow may not be able to go that long unpaid, and so there's a whole lot of different things, I think, that come into play in something like that. Some of you, I think, correctly pointed out that, what business is it that he would discuss this with his wife, and I, and I really have mixed feelings about that. You've got a man and a wife that are working together, and you're the boss. Should you not talk to things, to one another? I don't know. I think that's myself, this is a personal opinion and no basis in law whatsoever. Myself, I think that's a bit of a burden that you're putting on the employer who I think in probably good conscience and good graces, hired folks, married folks, probably helping them out, whatever the case may be. And now he's got this burden that he can only deal with certain issues, and got to keep things secret from the other person, and on and on. I don't know. Those things are difficult. Maybe could have been handled better by not hiring a man and wife in the first place, and that might be a reasonable reason not to do that. These things do come up, and something to keep in mind, I guess, as you move ahead. Unfortunately, in a lot of cases, you miss out on some good employees too. By not having a man and wife, man and child, your woman child, whatever the case may be, working together. So, okay, so again, my admonition is to pump up the discussions a little bit. I'm not seeing a lot of folks outside of the group jumping in. I know that's not a requirement, but as I go through these, and when I do start going through them, that's going to be extra credit, the potential to earn some extra credit there, and I don't see a lot of folks taking advantage of that. Maybe a few here and there, probably the same ones. Good for them. Okay, they'll enjoy that. probably by the end of the semester when they see their grade. And I'll have a lot of folks probably. What usually happens is about week 13, 14, they'll email me and say, geez, I see my grade's kind of suffering. Is there anything I could do? It's probably going to be too late then. The availability for extra credits right there. Take advantage of it if you want to now. Looking at the test scores and some of the other things, there's going to be a few of you that fall into that category, and yet the opportunity to address that is here and now, so take advantage of it. Onward. Let's talk about intellectual property. Let's go back to the beginning. Intellectual property and the property system kind of got mixed up here. This probably should go with the property stuff that we talked about in chapter 10, right? But when they redid the book and I was making up tests and whatnot, that's just not the way it worked out. So intellectual property includes some of those things, right? Trade secrets, patents, trademarks, copyrights. We'll talk a little bit about each of those. When we protect some of those assets, it adds to productivity. It adds, I would say, more of an incentive, and that's probably what we're seeing here. Individuals work harder to benefit themselves. Greed. Greed is not always bad. This is a case where, if you know that your property rights, your intellectual property rights, are going to be somewhat protected, it gives you a little bit of an incentive to produce certain things. So we'll talk about maybe some of those specifics as we go along. The Constitution, is that we're set up to promote science and arts. We're going to get a little bit of faster R&D. If you knew that you invented something, that the very minute you invented it, okay, anybody else could copy it. If they had the ability to. Would you feel a lot of incentive? I mean, wouldn't if you invented the new operating system for a computer, Apple's probably got the engineers that they could decipher that and figure it out in days, and could simply steal it and use it, right? And so you wouldn't have a lot of incentive to do that. And so we've created intellectual property rights to do that, to handle that, or to give you more incentive. Business assets, tangible, right? They're physical things, land, equipment, property, whatever. Intangible, right? Knowledge-based resources, trade secrets, trademarks, all those things, right? Can be employee skills. Trade secrets. Ooh. The old Burger King, or the Ronald McDonald trying to steal the secret from Burger King. I have to admit, I do think that, and I'm not a big fast food eater, and obviously we don't have a Burger King here in Havre, but occasionally when I stop at one and eat one of their burgers, I think they taste a little bit more like hamburger than a McDonald's burger. I got to tell you, in Havre, one of the best burgers is at the Oxford Bar. Not an advertisement, not a paid advertisement anyhow. I should tell Russ that maybe he should at least buy me a free beer every now and then for spreading a little bit of advertising on his behalf. But trade secrets anyhow, or knowledge or info, right? Kept it secret, right? We have to get reasonable measures taken. You'll read about Coca-Cola and their secret recipe. You don't hear as much about it as you once did, but they used to advertise very predominantly that there was three different parts of the recipe, and each part was kept in a separate place, controlled by a separate person. So it would take all three people, and each person didn't have knowledge of what the other two parts were to the recipe, and so it would take all three people to have to get together to disclose what the recipe might be. And whether that's true or not, I don't know. I do know that a few years ago, well, not long ago, 5 or 6, 7 years ago, because we talked about it at length in law class, some employees from Coke who felt that they knew the recipe actually called up Pepsi, or went and visited some folks at Pepsi, and were offering to trade that for money. And Pepsi did the right thing. Pepsi said, no thanks, thanks, but no thanks. We want to compete fairly, and we're going to turn your butt in. And they did. They turned him in, and the folks, I don't know what the disposition of the case was, if they ended up spending some time in jail. My guess is probably not a lot of time in jail, but they probably got some. I'm sure they got fired from their jobs and, those things. So the secret has to have some economic value. Now, we don't put a number on this. It could be $5, and that may be adequate, right? And they're covered under the Uniform Trade Secrets Act. Okay. Reasonable measures probably takes. It depends upon what the secret is. A recipe is something that's different than code. For a computer and whatnot, right? And so, the steps that you would take to protect those probably going to be different, right? Audit. You have an audit to identify what the resources might be, to preserve the secrecy. Might have some locking formulas. Talked about that's kind of Coca-Cola, protective firewalls when we're talking about code and those types of things. Certainly regulate visitor access. Businesses have to take reasonable measures to protect trade secrets from employees. And some employees, frankly, are in positions where they know those trade secrets. And what happens if they quit your business? Often there are contracts drawn up with those employees that would prevent them from taking that knowledge to another company. I think this is several years ago. I think the guy's name was Mark Hurd, and he'd been at Hewlett-Packard, and he went to work for Oracle. Now, Hewlett-Packard's been kind of struggling anyhow, but they make a lot of computers and whatnot, and printers, and they were concerned that he was going to take some knowledge with him and use it at Oracle. Even though Oracle's business is quite a bit different, I guess they were afraid maybe Oracle was going to get into that business, which they never did, and I think they filed some lawsuits, injunctions against Mr. Hurd, tried to get injunctions, to prevent maybe even his hiring. But I think ultimately he was allowed to go to work there, and they probably put some restrictions on, what he can't do. And I'm sure they keep their eyes open and make sure that he doesn't do things that would jeopardize the secrets that he brought with him from Hewlett-Packard. Confidentiality agreements, non-compete agreements, and these are the things when you get certain employees. No doubt those come up, right? That you would have them sign confidentiality agreements so that if they were to be employed, quit your employee and go to work someplace else, they wouldn't take those secrets with them. Of course, they have to be for a valid business purpose. It's got to have economic value. Again, doesn't have to be great. Can overlap the economic value with other things, other items that you might have that or other secrets that you might have, other trade, other business methods, whatever the case may be, I guess. I wonder if that guy has a patent on that. Interesting. I wonder if it's self-locking too. I don't know. I mean, when the woman gets in and sits down, if it just automatically does that, or I don't know. Good question. Civil and criminal, you can get injunctions to prevent use of or divulging of secrets. And again, that's what HP, I think, if I remember right, going back to the Mark Hurd case, tried to get, right? Could be a delay in taking the job, and I think there might have been a little bit of a delay when Hurd was going to go to work for Oracle. Damages if they do release that kind of information, and covered under the Economic Espionage Act. Patents. We'll go from trade secrets to patents, and patents are, we deal with new inventions, and it grants a legal monopoly. Now, patents grant a legal monopoly for a specific period of time, right? And when that time runs out, then there can be copying done and whatnot, but in the meantime, it's a monopoly, and it gives them the right to market it, make copies of it, sell, and those types of things. So think in terms of a lot of drugs, a lot of new drugs, right, receive patents. Lipitor was one that just lost patent protection, meaning that it had had a patent for like 15 years, and it was an extremely effective drug to lower cholesterol, and it in fact lowered the risk of heart attacks, fatal heart attacks, dramatically. Okay, and it had patent protection, and the company that owned Lipitor, and I don't remember which one it was, Merck or one of those big ones, made a lot of money during that time frame. And I remember, you don't see Lipitor commercials anymore, but you sure did toward the end of their patent. I think they were trying to stretch it for all it was worth and get as much dollars out of it. Because when the patent expired, then that allowed generics to come in, right? And generics were nice. Then it made it cheaper and more accessible for everyday people to come in. Okay, and you say, well, gosh, why didn't that happen earlier? If it's going to help a lot of people out. But the answer to that is, what incentive does the next company have then for creating the next Lipitor? That saves a lot of lives and does a lot of good, right? If all of a sudden they're told that, sorry, you can't make a lot of money off that. You can develop it, but then we're going to make it generic because we want everybody to have access to it. That would be difficult. If we came up with a drug that was going to cure cancer, wonderful. And honestly, if we had a cure for cancer, hopefully the government would step in and make sure that the company and the inventors got adequately adequately funded, adequately enriched, and we did make it kind of generic, right? That might be an exception. But one that was recently in the news, and it was interesting, I think it was Gilead Sciences maybe that invented it, but it was hepatitis C. And hepatitis C it's not an extremely common disease that people get. A lot of them have gotten it from blood transfusions and whatnot in the past, where they ended up getting exposed to it. And it's a disease that affects the liver, and it's one that they've kind of been able to treat a little bit and help people out using different types of interferon and whatnot. But they were never able to cure it by any means, and ultimately it would often lead to trials and tribulations for the person that had it, and probably early death. Well, Gilead Sciences came out with a drug regimen that would actually cure it. Okay, it would actually cure it. Now, the cost of the drug regimen, according to them, was $180,000. Again, you're not talking about a cancer thing where you're going to distribute this to a gazillion people, right? You're talking about a relatively limited market. $180,000 for that drug regimen sounds expensive, but it's a cure, right? It's something we haven't been able to do, and you're not going to have to take interferon then for the rest of your life, and you're not going to have to do some of those other things for the rest of your life, and nor is it going to eventually kill you. 180 grand, when I put it in perspective, seems kind of cheap actually for if you were to have had the disease, right? Tom Jefferson, look at that, way back when, first patent law, right? But Abraham Lincoln was the first American president to actually patent an invention. What it was, I don't know. Okay, you could figure that out. You could go to the patent office and probably look it up. To obtain a patent, you got to file an application. There is a fee, right? You got to explain the invention, probably using art, meaning you probably have to diagram it. Of course, a lot of that's probably done on computers and whatnot now, and describe the patentable aspects. You've got to research the patent office and see if there's some that are similar, and then describe how yours is different. Okay? And that can be kind of difficult. Okay, that can be kind of difficult. Subject matter, right? Processes can be patented. Machines, of course. Compositions of matter. We get into probably your drugs there, right? Improvements in other machines, products, those types of things, certainly. And certain plants. Okay, so especially you hear a lot about the GMOs, or genetically modified, and whether even in the modern, what we call genetically modified, but they've been crossbreeding plants forever, and the new ones, those of you that are in the grain industries know that you've had different varieties of winter wheats, spring wheats, those types of things. In fact, if you go way back, the invention of winter wheat was something that was relatively new. I think actually took place over in Russia, but being able to seed in the fall and harvest the next year, it was a little bit, that was certainly a new thing that happened. Characteristics have to be non-obvious, has to be novelty or new or whatever, and there does have to be some usefulness. So you can't just patent something just because it's different, right? If there's no usefulness to it that you can explain. Mere ideas, right, aren't patentable. So you probably have to prove the reasonableness of it, right? Okay. Business methods are historically unpatentable. That doesn't mean they're completely ruled out. It would probably depend on the method and what it does, okay, et cetera, et cetera. Algorithms, we hear a lot about algorithms in computer programming and whatnot, right? Only if tied to machine or transformation of a physical, interesting, right, or of a physical object. So I would guess algorithms that are tied to like Google's with their searches and those types of things are probably more of a trade secret versus a patentable matter. Okay, so that'd be a trade secret. That'd be subject to those types of things that they need to protect, right? Non-obviousness, ability to produce surprising or unexpected results, right? New and different things, that definitions that we should know, right? I don't get terribly wrapped up. I don't know if any of these would be on the test. I kind of doubt it, right? The duration of each, because I frankly would forget them. I'm sure we can look them up any given day if we want to. But utility patents, plant patents, and design patents. Okay, so different terms for the different types of objects or things, you know, that can be patented, right? Design, I don't know if that's the drugs or if that falls under utility, and I'm not 100% sure. Person probably have to look that up. Plant would be, of course, new things that have been developed, right? And you're protected, okay? People can't infringe on those things. Keep in mind that you know, especially when we get to drugs or even machines and those types of things, you know, that real similar products, they can be the same with just slight differences and still have separate patents. You know, use a awful example here maybe, but you got Viagra and Cialis. Okay, there's actually a Levitra, I think, too, that's similar if I'm not mistaken, and they basically in a lot of ways are kind of the same product and do the same things. I think they have some of the basic composition is similar, but then there's, you know, again, you're getting into it's complicated molecular structure that I don't understand, but at some point then there's just enough difference that allows it to be patentable, even though they really do the same thing. There's two separate companies that have those patents. You're seeing more advertising, I think, for those just recently, and one of the reasons for that might be similar to what I was talking about when I was talking about Lipitor earlier, is that the patent protection, I think, in a couple of years is up for Viagra, and I think Cialis is shortly after that, and I'm not sure. Again, because they're very similar, I'm not sure that it matters. You know, if you think about that, if the Viagra patent comes up first, you know, folks that use that product would probably, if they're using Cialis now and paying, you know, an exorbitant amount, whatever that might be, I don't know, they could switch over to the Viagra generic, right, for very cheaply. And so whenever one of those loses its patent, I think it's going to have a huge effect, at least on the pricing for the other and the availability of it. So patent trolls. So folks that go out and they look for patents, they might buy them up. Okay, there's a lot of patents that get filed that don't necessarily get used, and they'll buy them up. There's a lot of companies that have patents, especially now with the computers and electronics and those things, and they file patents, but sometimes they don't even have the ability then to make them marketable. And a patent troll might come out and actually buy that up and then take it to another company where, you know, they might have the ability to market it and whatnot. Now, pharmaceutical patents, again, huge. We're making progresses there. You can't click on the news, reading the news anyhow, without seeing probably mention of new potential drugs and whatnot that are in the marketplace. And patent genes. Can you patent the human genome? Yeah, that's interesting. Well, folks that went through and mapped out the human genome hey, they spent a lot of time and effort and money doing that, and so they patented that and that process of doing that and whatnot, and they were given some protection for that. And along came a company that wanted access to that and said, look, we think we can develop a drug, and I think it was a drug that would help treat cystic fibrosis, if I'm not mistaken. And the folks that had patented the genome said, well, sure, but we'd like to get compensated. And the folks said, oh, you guys are ripping off the consumers and whatnot. Here we could invent this new thing. And they said, we spent a lot of time and effort and money researching and mapping out the genome. Don't you think we deserve some compensation? And so those battles go on. The public good, especially in the long term, versus the public good in the short term, right? Trademarks, marks on what's produced represent. We're probably all fairly familiar with certain trademarks, right? Recognizability or distinctiveness, protection against confusion, right? So yeah, imagine you were blindfolded taken to a national fast food restaurant or a chain department store. When you took off the blindfold, did you likely know the name of the part, even if it didn't have the actual name? If you walked into McDonald's and all the McDonald's had been erased, but the golden arches were still there, or go back and look at that picture of Burger King, you take off all the things that say Burger King and Walmart, could you tell? Sure. That and that's powerful, and they rank that. You can get on sometimes. I think Forbes or Fortune or one of those. They'll rank the value of a lot of those trademarks. And up until recently, Coca-Cola was oftentimes recognized as one of the more valuable ones in the world. Just simply, it was distinctive and it represented that product well. I think it's fallen from the list. I think it's still up there in terms of one of the more valuable ones, but I think it's been replaced. And I don't remember what might have replaced it. I honestly don't think it was Apple, even though Apple's the biggest company in the world. Okay, trademarks have to be registered. They fall under the Lanham Act of 1946, so it's really not that old, just after World War II. Again, they have to be recognizable and distinctive, be trademarks, service marks, and I'll give you some examples, I think, of each of these. Certification marks, collective marks, trade dress, right? So there's a trademark, right? The Nike swoop or swoosh or whatever the heck it is. One that's recognizable that people know. We've all become very familiar with the Under Armour, the U and the A kind of one on top of the other, U on top, right? And if you watch Jordan Spieth play, you'll see the Under Armour often, right? And so those are real common. Service mark, you're in good hands with Allstate. That's one of their advertisings. You don't see Allstate advertising as much as they used to, but they still do, and you're in good hands. Notes a company's service as opposed to the product. Right? Allstate doesn't have products to put a trademark onto. Not like Nike, they're making shoes and shirts and jerseys and those types of things, helmets and everything else. Okay. So, service mark represents a service. Certification marks, I don't have. I put here, and I put Underwriters Laboratory. Okay, Underwriters Laboratory is a third party that would take a look at electronics and kind of, deem their safety and those types of things when they were sold. It used to be a big deal. I think now, now I'm trying to remember what it is, but you'll see on a lot of appliances, Energy Star. There it is, Energy Star, and that would be a certification mark, right? So the Energy Star might be on a Kenmore, it might be on a Maytag, it might be on a Westinghouse or GE or whatever the appliance manufacturer might be, but they've had a certification mark from Energy Star that says this is an efficient appliance. Okay, collective mark. I put over here an example of that might be MLB. Okay, Major League Baseball, National Football League. What would be some other? I'm trying to think of non-athletic types of collective marks. Maybe things like the Montana Bankers Association or some things like that. Groups that have come together. Okay, and they form organizations then, and so they have their own mark. I don't know if MBA, I don't know if Montana Bakers Association has their own logo or anything like that, but you guys probably think of some others. Trade dress, trade dress could even be a color. Think John Deere green, right? Pretty distinctive when you see that green. You think John Deere. Now, I think probably if you went to Sherwin-Williams, and I think this is probably right, and you said, hey, I want to paint my my outhouse John Deere green, you could probably buy John Deere green paint, and my guess is that John Deere would actually get a portion of that Sherwin-Williams or whomever would probably have to pay. They might tell you, we can make it look just about like that, maybe a little different, and then you wouldn't have to pay extra or something. I don't know, but John Deere green, something that's pretty recognizable. It's a trade dress. The Deere thing, of course, is a trademark. Okay. Must be used in interstate commerce, so not just little farmers market types of things. Must be distinctive. We kind of talked about that, right? Not generic, not prohibited or reserved. Folks for a while, I think, there's been some trolls that have tried to go in and trademark some things when a company came about, maybe, and the company hadn't jumped right to it and trademarked it. And those efforts have kind of been rebuffed. They've kind of allowed companies then that have those distinctive things, because sometimes they become distinctive and really recognizable before the company kind of realizes what's going on. I know that seems kind of odd, but it does happen that way sometimes. And there's an official gazette where those things are published and a person can look at. They have to be renewed. Okay, so somebody can steal a trademark, and if you don't renew it, there was a fight. There's a city in Colorado, I think, that referred to themselves as the cold spot in the nation, which seems odd because they can't be nearly as cold as some of the places here in Montana, and they had trademarked that. They had apparently taken some pride in it. Well, they forgot, and it lapsed, and a city in Minnesota, and Minnesota's got some cold spots, I'll tell you. They might rank up there with Montana when you get to the northern part of Minnesota. But they jumped on the patent, or on the trademark, and registered it. And so they got in a fight, and the city in Colorado said, just because we missed it doesn't mean we should be left out. I don't remember what the disposition was, but... secondary meaning, a public meaning that's different from meaning as a person's name or a descriptive term. So, could we take and trademark McGraw's? Well, I don't know. You got Tim McGraw, that's an artist, and right, and maybe I open up a restaurant that's called McGraw's, and I might be okay. He might not like that, and he might actually sue me. But let's say it kind of goes along and it becomes kind of famous, and I don't know. Okay, those things become the point here is that those things do become issues, and they do become contentious. Okay? Enforcement. Right, infringement. Usually they, the enforcement is to stop doing it. Okay, usually there's not a lot of, if I opened up a restaurant and called it McGraw's, and we did okay, and it wasn't until I franchised my 10th unit that Tim McGraw got a little upset. He might come in and say, well, one, either you need to change the name, or two, maybe it's okay, and I'll just kind of license that to you, and you can pay me a little bit of a licensing fee. If he was smart, that's probably what he would do, right? As long as he didn't feel like it was going to ruin his name and those types of things. It gets complicated, but I don't see a lot of trademark things that amount to big money changing hands. I just see it resulting in changes being made, changes being ordered. You have to stop doing this. You can do that. One that I remember that affected Montana, might surprise you, it had to do with beer, but when Big Sky Brewing started to become a little bit more popular, and one of the more popular beers was Moose Drool. And Moose Drool started to become really popular, and they were shipping it all over. And there was a company, I don't even know if this one still exists, up in Canada, that made a beer called Moose Head. Okay, well, and Moose Head beer was or whoever owned it, whatever beer company, brewing company in Canada owned it, it was a pretty good sized outfit, right? And they sued Big Sky and said, we think Moose Drool's too close to Moosehead, even though the beers were totally different. Moosehead was kind of a light pale Pilsner, Moose Drool, on the other hand, was darker ale. But they sued, and again, I don't think any money really changed hands, other than the lawyers got paid well, I'm sure. But in the end, they agreed that Moose Drool would limit its geographic area. And I should look up. I haven't looked up yet lately to see if Moosehead beer is still even made. I don't know. I have to check that out. There can be criminal violations, right? If we intentionally counterfeit products, and so that can happen. If somebody has a patent on something and you're intentionally counterfeiting it, that can happen. Federal Trademark Dilution Act, right? May not use mark same as, and I kind of already got ahead of myself and gave you the example there, right? The same as or similar to a famous trademark. Okay, I'm sure that Moose Drool is still trademarked. And I'm sure that Moosehead is probably still trademarked if it still exists. Maybe they've let it lapse. I don't know. Okay, and they came to an agreement about how they were going to move forward with those things. But you can see that you can't. There's an old Eddie Murphy movie, and it's kind of a cute movie. It's kind of a funny comedy. You guys might enjoy it. It's called Coming to America, and this wouldn't be allowed to happen, but instead of McDonald's, Eddie Murphy and his buddy, Arsenio Hall, I think is who it was, but they go to work at a place, it's like New York, Chicago, or something that's called McDonald's, M-A-C, capital D, and because it's Mac, it's more Scottish, and so it's got all the plaid types of things and whatnot going on. So, oops, excuse me for a second. I am expecting a call. Okay, sorry for the interruption. I am expecting a phone call. So, dilution I started on, right? Dilute the significance. You don't have to show public confusion necessarily, just that it might dilute their ability to sell Moosehead beer in Moose Drool territory. Copyright. Copyrights are kind of interesting, right? Copying, marketing, it's for a limited time, so kind of like patents, right? Gives the right to copy and market certain things. Okay, property and creative expression. So think art, think music, right? Criteria, but also think written things, any types of written things. Blogs could be those types of things. Original work, fixed in a tangible medium of expression. That used to be easy, right? That used to be a canvas. Somebody painted on an artwork. It was music that somebody created and recorded, right? Put it into a old cassette or some type of recording tape or whatever, right? Of course, it's all digital now. And so the medium of expression has changed. If you're posting a blog, is that all of a sudden copyrighted? Yeah, the answer, our courts have said, I think that's right. Okay, must show creativity, so it has to have some uniqueness and some creativity to it. And this is for authors, not inventors, right? So authors, artists, etc. Protection attaches at creation, and so to a certain extent, something when you create it is protected by copyright. Okay. Whether you do anything or not, you don't have to put the little copyright symbol. You don't have to put any of those things necessarily, and there's a certain protection. Okay, but if you want federal protection, then you should file that. Okay, the copyright symbol, you can put it on if you want to. Okay, fair use. What's not infringement of copyright though? So there's lots of people have made music, right? And if I my barbershop group, we sing a lot of music that's long since been copyrighted and still has copyright protection. Okay, most places, if you're singing in a paid performance, the artist or the original creator of that piece of music is entitled to some compensation. If we're just practicing, of course not. If we're just out singing on the street corner, we actually do that sometimes, okay, and we're not collecting any money or doing anything for that, then the creator is probably not entitled, right? And these are gray area things. Okay, I use a lot of photos and pictures and stuff in these PowerPoints. Are they protected? There might be some protection for them, but I'm using them in a academic setting, and I'm using them to kind of make a point. I'm not being paid, extra or separately or anything like that for using them. I'm not making any more money. And so, an example would be Mickey Mouse. If I put Mickey Mouse on here, Mickey Mouse is protected. It's copyrighted. There's no question about that, right? Walt Disney or Disney's entitled to some money if I used Mickey Mouse to make money. If I put Mickey Mouse ears on one of my PowerPoints, Walt Disney's not entitled. Okay, and so fair use is just an understanding, and again, it's a huge gray area. I wish I could tell you that there's some black and white there, but there's not. Okay, to determine what's actually correct and what's not. There's a lot of case law that might determine that, in terms of when music becomes something that the creator deserves to be compensated for. There's case law for when Mickey Mouse, when his use is something that should be compensated for. Digital age issues, wow, right? File sharing, yeah. You guys, Napster was a big deal. We used to talk about that a lot in class, and there was other file sharing services that lots of people knew about. You don't hear so much about that anymore, and I'm sure there's still folks that you guys download lots of free stuff. It's still probably subject to copyright protection, so it's probably illegal, but it's happening all the time. Every now and then I go on YouTube just for the hell of it, and I'll see if an old movie, is watchable on YouTube, and yeah, probably 7 times out of 10 it is, and I can find it, and then 2 weeks later you might check again just for the hell of it, and it's not on there anymore. It says, hey, this was taken down due to copyright violation. And so, people are posting those types of things, and it happens, and it's a whole new age, I guess. Okay, and certain amounts of that are illegal, and the companies the company that owns the rights to those movies and whatnot, just try to protect them. Okay, you guys, give that a try and take a look, and you might see what I'm talking about. Copyright Act, right, makes it illegal to efforts to get around protective devices. So if you rented a movie, a DVD, and you were savvy enough, I'm sure you could figure out how to capture that and save it on your deal, right? Technically that's legal if you leave it on your computer and you only use it yourself. Okay, but if you shared that then with somebody else, then it becomes illegal. Okay, restrict certain recorders and camcorders. People literally they would go to movies and they would take their digital recorder. I can't imagine that the quality was all that good at the time, but they would record the movie on a digital recorder and then take it home and upload it to their computer and share it with people. Internet service providers are required to kind of keep track of some of this stuff, right? They've got some burden placed upon them to try to keep track of that stuff. So international gets to be different. I don't think I talk a lot about this on the test or otherwise. There's no real international agreements. Companies that have things manufactured in China oftentimes know that they're going to get copied, and those products may or may not end up back in the U.S. They may, in some cases, through different different routes, make it back into the U.S. But oftentimes, it's copied and they use it in China or they use it in wherever. India, Indonesia, Australia, who knows, right? And the U.S. company may never be compensated for it. And I remember watching a lot of some documentaries and stuff about that, and it says, well, some of the companies just accept that as a cost of doing business, and it probably is. To get your goods and stuff manufactured more cheaply in other nations, it was worth it maybe to give up some of that copyright protections that you might enjoy here in the U.S. So I guess that would be a case-by-case thing, but so a lot of those things are not protected. So there you go. Okay, that's kind of it for that, and I think I'll wrap that up. I'll come back and do Chapter 13 a little bit later, because this one's getting a little long in the tooth, and that way you guys could watch it on separate things. Chapter 13, we're going to talk a bit about, what's that, crime? Ooh, yeah. Yeah, I like is that the crime one? Yeah, I like crime. I mean, well, I don't like crime. I kind of like talking about it. So here we go. I got more funny things for the PowerPoint.